Right, good morning everybody and welcome on behalf of Exeter Chamber and in Exeter as we deliver a series of very topical workshops for you all this morning. As you know, Brexit is an evolving situation and there are a number of us in business that have possibly not prepared for what might or might not happen. So hopefully today you're going to get some really good tips. The speakers have been recruited for their areas of expertise and they're going to come up shortly to do a very brief intro into what their workshops will be about today. The Exeter Chamber is the voice of the business community and it's great to see a number of members and non-members here this morning. We are responsible for lobbying on behalf of the business community. We run a series of events, not only networking events, but knowledge events as well. And there is opportunity for you today to find out more about how the Exeter Chamber can help you. Lisa, Jen, and Ali have a stand in the other room. So if you'd like to find out more about membership, please go through to them. I'd like to take this opportunity to mention that in your packs from in Exeter, you have the opportunity to win some gift vouchers for your team. So please do have a look at that. So I've just realized I've not actually introduced myself properly. So I'm Jo Kane, I'm one of the board members of Exeter Chamber, and I'm also the Managing Director of Cathedral Appointments. So without further ado, I would like to introduce you to Tim Lane of Stevens and Scone, who is going to do a brief intro on funding.
Thanks. Which one is it?
It's that one over there.
That one there, thank you. Good morning. Thanks for that introduction. I'm going to be talking about the issues that might arise in respect of the European state aid regime and in respect of grant funding in general. As I'm sure you're all aware, the South West in particular has benefited over the previous years in respect of an enormous amount of grant funding. And it's, the purpose of this talk is to explore some of the ways in which that might change going forward and the ways in which businesses can prepare for it. I must say I'm very pleased to hear that there is a delay so that I can stand here and tell you what I think you should do now and not what I think you should have done 3 months ago. So without further ado, that's me, corporate solicitor at Stevens Scone. I have 3 points I'm going to talk through today in a bit of detail. So, state aid. By state aid, what do we mean? We mean the underlying regime imposed as a key regulation forming part of the underlying European treaties, which governs how public subsidies can impact and be fed to undertakings in a way that doesn't affect trade between member states. It's a key piece of EU legislation. It's enshrined within Articles 107 and 108 of the EC Treaty. Basically, what they say is that if you're an undertaking, i.e. an organisation putting goods or services onto a market, you're in receipt of funding, and that funding can be any form of financial accommodation, so including grants, loans at non-market rates, guarantees at non-market rates, or any other form of subsidy, then in effect, these rules will apply if there's an impact on your ability to be competitive, i.e. you've got a leg up over your competitors, and that has the potential to affect trade between member states. By affecting trade between member states, the underlying rules generally assume a very low threshold, so even relatively modest amounts of funding to organisations can impact on trade. The way in which you generally deal with state aid, as a bit of context, is you tell the European Commission, and the European Commission will make a decision on whether they think that's okay or not. The other ways of getting sort of in or around or over or under or through state aid are to take advantage of various exceptions that are in place. Some of you may be familiar with the General Block Exemption Regulation, the De Minimis Regulation, and lots of other pieces of primary EU law that deal with state aid. So coming out of the EU is going to have an impact on all of that. really just looking at the impact of what's going to happen in respect of a no deal. Basically, what the UK government has said is that state aid is here to stay. It's going to be business as usual. What they're going to do, the day after exit day, in the event of a no deal, is impose an EU-wide or a UK-wide subsidy control framework operated by the Competition and Markets Authority in the place of the EU. What that means is the CMA will be responsible for deciding what's lawful aid, what isn't lawful aid, and will be applying rules as currently set out within the European legislation. In the event that there's a deal, to a certain extent, it's going to be business as usual. We're going to, at least until the end of the transition period, still be subject to all of the same rules around state aid and grant funding. We'll still be accountable to the European Commission in the event that there's any issues in connection with state aid. But following that, again, really, I suppose it's anyone's guess. We'll look in my workshop in more detail on what might be included in the following the transition period. But within the political declaration, by and large, the detail of what's going to be covered is quite lightweight and quite sketchy. So that's state aid. Implications for applicants for and recipients of EU funding. Basically, again, as I'm sure you're aware, Cornwall and the South West in general has had an enormous amount of EU funding over the last years. I guess in Cornwall we've probably got used to that. And really, it's just worth exploring what's going to happen in the event of a deal or a no-deal Brexit. Broadly, if you've had funding and you're continuing to work through the terms of your funding agreement, you're performing your deliverables, then I think you should assume it is business as usual. If you're in the process of applying for grant funding and you haven't yet had any final binding grant funding agreement, then the implications are slightly different depending on whether there's a deal or a no-deal Brexit. In the event of a deal, the arrangements are effectively going to be business as usual, again, at least throughout the transition period. What the European Commission has basically said is that while we continue to pay into the budget, as we're likely to do until the end of the transition period, then we will still be able to take advantage of the European funds into which we presently participate. With regard to the event of a no deal, again, that depends on the fund, really. What the government has said is that it'll offer a guarantee in respect of certain EU funds. What the guarantee basically says is that if EU projects are delivering good value for money and fit domestic strategic priorities, then they will continue to be honoured by the UK government even in the event of a no-deal Brexit. I think the points to bear in mind there just relate to what good value for money and what fits domestic strategic policies actually means. As I'm sure you're all aware, after any comprehensive spending review or any other change of policy, what the government considers to be good value for money and domestic strategic priority can change very quickly. So it's one to keep aware of. But in any event, assuming that your project is going to continue to be funded by the guarantee, then you will largely be followed and managed through existing processes, including appropriate auditing, monitoring, evaluation arrangements that you would be complying with as a matter of course. The guarantee will also apply, well, it will primarily apply in respect of applications to giving you direct reassurance in respect of applications to MHCLG or other UK government funders who are acting as an accountable body. But in the event that you're applying direct to certain EU funds, such as those listed there, the UK guarantee extends to say that as long as you've basically told the government that you're involved in one of those projects, the government will continue to honour those. So if you've got a grant-funded project where you're bidding direct to the EU, then it's worth just having a look at the www.gov.uk website just to see the key the key protections that are there and available for you, and what you've got to do if you want to ensure that your grant funding is safeguarded. What we've looked at so far in this talk is a bit of the black letter law around state aid and around implications for EU funding in the event of a deal and no deal. I guess the other thing I'd like to talk about really as a sort of corporate commercial lawyer is the other ways in which your ability to continue to deliver your obligations under your funding agreements can be achieved. What I'm thinking about here is that we've all seen grant funding agreements with KPIs, with deliverables, with certain numbers of jobs or things that have to be produced as part of the grant funding process. And they're contractual obligations that you've got to do, regardless of whether there's Brexit, regardless of whether there's any other issues that might impact on your ability to undertake a business and perform those roles. So really, it's just looking at some ways in which we can get sort of around or over or under some of those issues that are raised. First and foremost, it's worth looking at the grant contract. For example, if you've got a set of deliverables that as a result of Brexit-related circumstances you can no longer achieve, then it's worth looking to see if you can get out of that contract. In the first instance, looking for the provisions around change of control, what you might need to do to, or change of control or change of project to change the scope of what you're asking for and what deliverables you're going to need to be providing. Alternatively, you could look to see whether the contract's going to be frustrated or whether you could use any force majeure clauses, although we'll touch on some of those issues in a bit more detail in my seminar upstairs. Assuming you can't change the terms of the contract, then it's worth thinking about how you deal with your ability and consolidate your ability to continue to perform your obligations under that grant funding contract. Really, I suppose then it's about looking at how you can best risk assess and manage any commercial issues that you may have. What I'm thinking about here is that you need to identify exactly what is going to stop you from achieving those KPIs. Whether it's that your productivity may go down, you may not be able to employ so many people, whether it's that you may find that particular contracts you're relying on aren't going to be so lucrative now. The point is to pinpoint what was going to cause that concern and ensure that you've addressed it. As I say, the good thing about raising this point now is that hopefully it gives businesses that haven't had a chance to consider these things yet a bit of time to do it. If I'd been stood here now, we're facing a no-deal Brexit, to say you should have done this 3 months ago probably wouldn't be that useful. But the kind of things I might be looking to address are the provision of Brexit clauses, as they've widely been known within the legal profession, within your contracts. And what we're looking for there is provisions that expressly deal with key issues and risks that emerge in the course of Brexit-related changes. So we're thinking about how you might deal with things like changes to tariffs, changes to border controls, and how you might deal with them within a commercial contract. For example, if the particular risk that you're facing is that a change in exchange rates might mean that the funding, that a contract is no longer going to be lucrative, then what you may be looking to do to mitigate that is to say that in the event of a change of exchange rate beyond a certain rate, you have the ability to renegotiate the contract, or you can trigger a dispute resolution procedure, or you can end it. I suppose the other point to bear in mind is also thinking about what other contingencies you can put in place around the contractual arrangements. For example, if you've got a supplier that's for a large proportion of time has been providing you services on an ad hoc basis, maybe now's the time to look to formalise that into a more formal binding framework agreement. And there's always a commercial discussion to be had, I suppose, as to whether actually having contractual certainty is useful or worth paying for in the circumstances. More broadly, I suppose the other key issue that you might come across relates to your ability to deliver match funding that's needed. What I'm thinking is that institutional lenders are going to be facing a significant period of change and realignment with so much of the existing financial services law embedded within key principles. There may be some lack of appetite or risk averseness going forward to make particular investments, and it's just worth ensuring that as and when you're able to, you've identified what those risks are and been able to mitigate them as appropriate. Other commercial issues, well, again, we're experiencing a lot of potential changes in regulation, which I'm sure some of the other speakers are going to talk about in more detail. And yeah, I think that's the main point I wanted to make there. As I say, just touching on some of the other points, which I'm sure some of the other speakers are going to touch on in more detail. So here's just a few key points, summing up how to deal with grant funding, state aid in the context of a no-deal Brexit or a deal. Ensure you understand the rules that will apply in the event of a deal. Know your rights in the event of a no-deal. Take what action necessary is now to secure your funding. Keep up to date. The www.gov.web website is actually a very useful source of information for a variety of topics. Ascertain your ongoing ability to perform grant funding obligations, and as far as possible, look to mitigate any risks. And finally, state aid is here to stay. Just make sure you continue to ensure compliance. Thanks very much.
Thank you very much, Tim. So Tim's workshop will be helping you wade your way through the implications of state aid and EU funding, and also what actions you need to take within your business. So, I'd like to welcome onto the stage Charlotte and Stephen Jones for their presentation with regards to intellectual property.
Good morning, everyone. I'm Stephen and this is Charlotte. We're from Mitchell Solicitors. And like everyone, I think, we find it difficult to follow all of the twists and turns of the Brexit debate. And we still don't know, even after the events of this week and the last few weeks, whether we're going to be leaving the EU with or without a deal, whether if we do leave with a deal, it's going to be the one negotiated by the Johnson government, or some other form, or whether there'll be another referendum or a people's vote or whatever. So we can't give you the answers to those questions today, but Charlotte, what can we do?
What we can do is help you to understand what the implications for your intellectual property rights will be. Whichever of those scenarios eventually come to pass, it won't surprise you that IP rights weren't the main sticking point in terms of all the difficulties and the twists and turns that have happened. But what we can say is that the various government departments which are responsible for the aspects of IP rights, which we're going to be talking about, have been working to make sure that there is a plan on what happens next. And in particular, the UK Intellectual Property Office, the UK IPO, has been very much involved with drawing up these plans.
And the good news is, because these issues of intellectual property haven't been, for the most part, particularly contentious, they've not really altered between what was in the original Theresa May draft agreement and the latest version. In fact, they're identical. And also, the government's published various notices on what might happen if we still manage to leave the EU without a deal. So where appropriate, in our workshop this afternoon, we'll highlight, or later this morning rather, we'll highlight where this would have implications for continued protection of intellectual property.
So in terms of the IP rights that we're talking about trademarks, we're talking about designs, patents, confidential information and trade secrets, and then copyright, which includes sort of database rights and software. So copyright is something that covers a lot of different things. And some things change more than others, and that's what we're discussing in our workshop.
And we'll be looking at it as to whether there's a deal or a no deal, as I said, and whether the situation will change. Obviously, one of the main issues between whether we leave with a deal or without a deal is whether there'll be an implementation period or a transitional period, which will affect when some of the things we're discussing are going to start to happen. So one of the things we'll be discussing in some detail this afternoon is about trademarks. So I thought I would show you this one here, which you may recognise, which is the UK's first ever registered trademark, with registration number 1, registered in 1876 and still registered today. And you can see that in this painting, which you may recognise, painted in 1882, it's very easy to see what beer the bar at the Folies Bergère is serving, along with the champagne and other things. So it's nice to know that in 1882, the bar at the Folies Bergère in Paris was selling good old English Bass beer. The point is that, Charlotte, since 1996, we've worked in a different way with the EU trademark system.
Yeah, so in terms of the most commonly, trademarks have been registered at the EU Intellectual Property Office, the EU IPO. And once we Brexit, however we Brexit, these EU trademarks will have no effect in the UK. So there is going to be some change, and that's something which there are sort of extra detail, which we're not going to go into right now. But in terms of our workshop, please do come along, and we'll be discussing sort of the transitions that need to take place for those with current EU trademarks wanting to change those to UK trademarks.
I think if you do come along to the workshop, we'll be able to reassure you that your trademark rights are not going to disappear, but there are some matters of detail that you need to pay attention to. And the same pretty much applies to registered designs. If you have registered design protection, then there is going to be a similar way in which that's going to be dealt with, depending on which way we Brexit. And that is an example of something that's covered by a registered design. I don't know whether you recognise this trunky suitcase. And it's a remarkable aspect of the kind of law that Charlotte and I deal with all the time, that this little suitcase actually became the subject matter of a legal case that went all the way to the Supreme Court and was adjudicated on a couple of years ago. How about that? So in relation to patents, those of you who are involved in patents for inventions in your businesses, the situation there is a little bit easier to deal with and explain, because there's essentially no change to the regime for patenting inventions in Europe, because it's not governed by an EU regulation or an EU law. It's governed by an international agreement which won't be affected by Brexit. But there have been talks for a while, and I don't think the slide is up there, but there have been talks for a while about a new system for a unified patents court and a unitary patent, which will be impacted by Brexit, and we'll tell you more about that this afternoon. But the main story for patents and the European Patent Convention and the European Patent Office is that it's business as usual and not affected by Brexit. Charlotte.
So in terms of the other IP rights, trade secrets, copyright, geographical indications and databases are something which some aspects change, as Stephen said, in terms of rights that are more governed by international treaties aren't necessarily going to change at all, whereas some aspects, for example in copyright, the EU cross-border copyright mechanisms will change. So there are more detail that we can give you, but again, we're not going to tell everyone now because not everyone might want to know, but come to our workshop and we'll tell you there. So thank you very much.
So finally, we look forward to seeing you in the course of the day and hopefully later on in the workshop if these matters interest you, and thank you very much for listening.
Thank you.
Thank you.
So thank you very much to Charlotte and Stephen of Mitchell Moores. Their workshop will help you navigate your way through the implications and the continued protection around trademarks, patents, and what will have effect and what won't. So thank you very much. Okay, I'd like to hand you over now to John Dunkley of Wallens.
Thank you. Hello, I'm John Dunkley from Wallens. I'm a partner. I specialise in employment law. I was formerly a lecturer in European law, but I don't tell many people that at parties at the moment. So, so welcome to the government Brexit game show of deal or no deal. I need to work out how to use this, so just bear with me a second. Wow, this is slow, isn't it? Wallens. Right, there's a few things that I want to talk about today very briefly now and in more detail in the workshop. At the moment, we don't know what's going to happen, as we've heard from many of the speakers, but there are three possibilities, possibly more, but three main possibilities. So the first one is that we actually remain. It's probably quite unlikely, but it's still a possibility. The Lib Dems would like to see us remain. And if we do remain, then in terms of pure employment law, nothing is likely to change. All right, everything will remain largely the same for a long period of time. If there's a deal, then obviously it depends upon the deal, and we know something about the deal that's at least being proposed, and that may be tweaked and changed over the course of the next few months or weeks. And if there is a deal, then again, pure employment law terms, probably nothing will change substantially, certainly not in the short term. We're expecting a reasonably long transition period in any event. So in terms of law, no substantial change. If there are changes in the longer term, it's unlikely to affect employees' rights because it's too politically unpopular. Who wants to take away employment rights around the election time? So I think we can see that things will again stay fairly similar. And if there is a deal, then, if there is no deal, then there is most likely to be a significant change. But again, it's not going to happen quickly because it will be too politically unpopular to take away employment rights. But there will be changes in the longer term, and our laws will gradually diverge with those of the EU over a period of time. But even then, if we want to maintain a close trading relationship with the EU, even if there is no deal, then many of the laws will remain very similar. And we are really largely committed to a number of rules which also affect employment in the longer term. So data protection, for instance, I'm not going to talk about that now because somebody else is talking about that, but we're fairly committed to keeping data protection rules aligned with the EU, and that will be the same for many employment laws, we expect. So why am I up here talking to you then? Well, there are many things that you need to do to plan for Brexit. So your business will need to look at what you're going to do to plan. And you need to look at it in the context of deal, no deal, or even remaining inside. Now, this will depend upon your business. So all businesses are different. If you run a kebab shop in Barnstable, it's unlikely that Brexit will be a huge issue for you, certainly in the short term, because you're not likely to be doing too much trade internationally. You may have some employees from outside the EU, which there might be an immigration issue, but effectively you're selling kebabs and you'll still buy your ingredients and you'll still sell your kebabs to the local population, and you may not need to do very much at all, and that might apply to many of you in the room. Similarly, if you are doing a lot of trade with other EU countries, you have lots of EU employees, or you have lots of employees moving in and out of the EU on a regular basis, then you're going to have to do much more planning, aren't you? Your plan may be considerable. So you need to come up with a plan, but it's going to be different to the people sitting next to you. All right. In any event, you need to have a look at your current workforce. What do they do? Where are they? Can you move them if you need to? That's move them physically. I mean, you might have people that would jump at the chance of going to work in France for a few months. Equally, you may have people that have never left Devon and never will, you know. And so if you need to move people around post-Brexit, then you need to think about how you might do that. That's based upon individual personalities, but of course you may need to look at their contracts of employment. It may be that you can't move them very easily because they're on contracts of employment that require them to stay in the UK. And you may need to think about changing those. You may have mobility clauses in your contract which allow you to move your employees around to an extent. You may need to look at that, for instance. In any event, many of you will be keeping your eye on the news and on various websites and various other ways you might keep up to date. you're going to need to keep doing that, and there are various ways that you can do this. So you can look at legal changes. We've heard from a lot of lawyers today, unusually. Hopefully there'll be a few less lawyers around the rest of the talk. But certainly you need to look at legal changes that might impact on your business. But it's not just legal impacts, it's administrative barriers to trade as well. And there may be all sorts of rules on what can be traded cross-border, and you need to get advice. And one of the main places of getting advice is the Chamber of Commerce, who are hosting today's event. Little plug there. But you all have trade organisations as well, and government guidance on such technical matters. You can go and see a lawyer if it's to do with something technical that's critical to your business, for instance. There's various places where you will get information from. But the reason for mentioning this is that regardless of the fact that employment law might not change overnight, the way we do business within a new EU or outside of the EU will change, and any significant changes to your business will mean that you will need to look at your workforce and decide what changes you need to make to your workforce. So many of the employment issues that we're talking about today are indirect. They're not directly affected by Brexit, but Brexit will cause the way you do business to change, and that will mean changes to your workforce. Have a look at some of the changes that might occur. So effectively, after Brexit, what might happen? So your workforce, might it increase or decrease as a result of opportunities and threats caused by changes to the EU and its makeup? Well, you have new opportunities. A very good friend of mine, his business will probably fold if there's a no-deal Brexit because of possible import duties in the area he works. But he's one of these people that will set up a new business and do something else. So things will change for him, but they won't necessarily be detrimental. He is currently making a lot of plans, depending upon what happens within the EU. But it might not be as important in your business. I say, what if Brexit is delayed further? I wrote that before the recent announcements and how it's come true. And what are the costs of making employment changes? It's not a cost-free environment. When you make changes to employment contracts, there often has to be some sort of incentivization, or you might have to make people redundant, which there will be a cost to. Have you considered what these will be? All right. And have you considered other ways of working? All right. Do you need employees? Right, don't tell them that at the moment, but do you need employees moving forward? Can you use self-employment as an alternative to reduce your risks based upon new threats and opportunities? Can you contract out services? Can you use separate corporate entities in other EU countries to manage or alter the risks associated with what you do? These are all things that we can talk about in the session on employment. So, moving on to the workshop session, what are we going to be talking about if you come along to my session on employment law? Well, there's a few things. Firstly, what laws are likely to change in a no-deal or in a deal Brexit environment? We've got things like agency workers directives, transfer of undertakings regulations, which I certainly won't bore you with at the moment, but you might be interested in the session, changes to discrimination rules and changes on things like collective consultation. A whole range of things which are expected to change, particularly if there's a no-deal Brexit, but probably marginally. Do they affect you? How mobile is your workforce? We're talking about stress testing your workforce. Look at it at the moment, and how easy will it be for you to make changes if you need to? How much will it cost you? Do you need to change employment contracts? Or do you not? You might not need to, it might be fine, but if you do, looking at it now is a good idea. Normally you can only change employment contracts by agreement, for instance. How do you get agreement? Well, usual way is to pay people to agree, but there are other ways to get people to agree to change contract terms. And also employment alternatives. What can you do to avoid having to deal with employment issues head on? Can you hive the problem off onto somebody else? Okay. So these are sort of things and many more issues that we will be dealing with at the employment law session. I give you a guarantee that I will answer every question that is asked of me in the session. So there we go. Can't say better than that. So thank you very much. Thanks for listening and thanks for coming along.
Thank you, John. You could be there a long time. So Jess, join John Dunkley of Wallens for his employment workshop this morning. The next speaker today are Charlotte and Hannah from Ashford Solicitors.
Okay, thank you. Morning, everyone. So my name's Charlotte. Get that there. And I'm a solicitor at Ashford's Solicitors. I'm wearing the same outfit as in that picture, but I do have other clothes, so that's good to know.
Morning, I'm Hannah. I'm also a solicitor in the Commercial and Data Protection team at Ashford's. So I think our presentation today is going to focus around the 5 top tips for a no-deal Brexit and data protection. And like with many things that we're going to be discussing this morning, the impact of Brexit on data protection very much depends on whether or not we get a deal. What is probably quite helpful to note and very reassuring is that all of the time that you spent preparing for the GDPR on the lead up to the 25th of May 2018 is absolutely not wasted. And this is because when the UK leaves the EU, and this is whether or not we leave with a deal, all European law at the point at which we leave is going to be incorporated into UK law. So this means the GDPR, as an EU regulation, is going to continue to apply, and as will the Data Protection Act 2018, as an act of UK Parliament. So regardless of whether we have a deal or not, you're going to continue to issue your privacy notices, conduct your data impact assessments, respond to subject access requests, make sure you've got your processing provisions in place with your third parties, and also the ICO are going to continue to regulate data protection in the UK. They're going to be issuing helpful guidance, going to be issuing fines for non-compliance. So this is where we start with tip number 1, continue to comply with the GDPR and the Data Protection Act.
So our second tip to help you prepare for the effect of a no-deal Brexit or a no-deal at the end of a transition period is to make sure you're reviewing and auditing all of your data flows so that you're understanding where you've got personal data flowing to and flowing from. So in the context of Brexit, it's going to be most important to look at whether you've got personal data coming from the EU. If you've got customers in the EU, are you holding their personal data? You need to be thinking about all of that in the context of your international data flows. So as Hannah was saying, you might have already done a lot of preparation for GDPR, and hopefully as part of that you would have thought about where personal data is flowing to and flowing from. So dig out all of that work you did previously. Hopefully you've got notes. Have a look at it, see what's changed. Maybe you've got new customers. Maybe you're going to be setting up a base somewhere in the EU, and that means you're going to be hosting data there. Maybe you outsource your data hosting to somewhere in the EU. You need to be thinking about all of that so that you understand the steps you need to take in the event of a no-deal Brexit. So, if you need to, you've done your data mapping and you think, oh goodness, we've got lots of personal data here. It's flowing from the EU, flowing back, it's going everywhere. Look at what appropriate safeguards you need to put in place. So, depending on your business, it could be different. But the most likely and suitable safeguard for a lot of people will be standard contractual clauses, or what are called model clauses. So after Brexit, in the event of a no deal, or if at the end of a transition period there is no deal, then what needs to happen is that the UK will be a third country, which means that personal data from the EU can't just be sent over to the UK without a safeguard in place. So you can put in place model clauses. It's a set of clauses written by the EU. They cannot be changed, but both parties enter into them, and it allows personal data to flow between those countries. So that's probably going to be the most appropriate mechanism for most businesses if you're having to deal with that situation. There are other mechanisms like binding corporate rules, and there are some derogations, but for most businesses it's going to be model clauses. So we're already starting to see some people putting them in place, getting ready for Brexit. The ICO website has a lot of guidance about how to put those in place, and you can put them in place so that they only trigger in the event they're necessary, and that's sometimes good preparation for a no-deal Brexit. We're mainly going to be focusing in our workshop later on international data transfers, but I just wanted to mention here about other things that will be affected by Brexit in a data protection context. So you may need a new supervisory authority who's going to govern your practices in the EU. So the supervisory authority is the Information Commissioner. They're the person in the UK that deals with all of your data protection regulations. If unfortunately you had a data breach, you'd have to speak to them, that sort of thing. There's a different equivalent of the ICO in every European country. And what happens under GDPR is they have what they call one-stop shop. And under that, if you had a personal data breach that affected all of your customers in the EU, basically, if you're a UK business, you only need to be speaking to the ICO, and they'll deal with the whole breach affecting all of Europe. After Brexit, the ICO will only regulate the UK. So if you did suffer a personal data breach, unfortunately, and it affected your UK customers and customers in France, let's say, you would need to be dealing with the UK, and that's the ICO, and then in France, you need to be dealing with their supervisory authority, the CNIL. So it's important for you to just consider that and have that on your radar. It'd be quite easy if perhaps you do just have one particular European customer base. So if it is France or Spain, it'll be quite easy for you to think, okay, I know who I'm going to have to deal with in that situation. So just give it some thought. Similarly, if you're operating in the EU, then you may need to be appointing a European, what do they call it? A European representative, typo there, not a Euro-P representative, but a European one. And that will be the person that your European customers would have to liaise with if they had any data protection queries, if they wanted to raise a subject access request, that kind of thing. And the idea is that that gives EU citizens an easier right of access to those companies that hold their personal data. So just another thing to keep on your radar if you are going to be operating still in Europe after Brexit.
So that brings us to the fifth and final tip, which is to keep your data protection practices under review. Now, this is important in light of Brexit, but also, regardless of Brexit, this is something that we should all be doing. Data protection law is a very changeable and developing area of law. So you want to ensure that you're complying with the GDPR, the Data Protection Act, the Privacy and Electronic Communication Regulations, also keeping a careful eye on guidance that's issued by the ICO. Monitoring your data transfers, and it's really just being alert. So if you know that you're starting to receive personal data from a third country that you haven't received it from before, you're transferring personal data to a third country that you haven't transferred to before, it's just asking yourself, have I got appropriate safeguards in place? Do I need to think about additional safeguards? And because both a deal and no deal Brexit are very much on the table still, just keeping everything under review.
Okay, so that's everything we are going to speak about this morning. In the workshop, we're going to be looking more at international data transfers and how you can prepare for those. So hopefully see some of you shortly. Thank you.
Thank you very much.
Okay, thank you very much to Charlotte and Hannah. It's very good to hear that all of our efforts around GDPR were not wasted, but there's going to be some further implications for us, so please go along to their workshop to find out more. I'd like to welcome now Linda Middleton-Jones and Mike Court.
Good morning, everybody. Good morning. Oh, there it is. Sorry. Right. Good morning. Welcome to our presentation. My name is Linda Middleton-Jones. I'm joined by my colleague and compliance specialist, Mike Court.
Good morning, everybody.
We're a team of specialists that work throughout the Southwest. advising on any companies that want to buy or to sell overseas. We work with many of the chambers, and delighted to be here with Exeter today, but we're also a small business member of the Institute of Export, and another excellent organisation. These are some of the things that we do. So, can you hold that mic? As I was writing this, I think in music sometimes, who remembers the Temptations? Anybody? Anybody's going to own up to it? Can you remember their song, Ball of Confusion? Anybody like to sing it? No. But it sort of looks like this at the moment. There's lots of opinion, there's lots of anger, divided society. But you know what? We're British. We're good at being agile. That's what we're good at. So we must not forget that we have our heritage. We have our years and years of being traders. So we can do this. Right? What we have to do is learn a new language. And in that language of international trade, of export, there's lots of acronyms, and you'll hear lots of those. So we're actually all learning. How many of you out here knew about tariffs before 3 years ago? All of you now. Okay, thanks. But a lot of people are learning because of the press and what's going on. And exporting law, or the law of international trade, is a mixture of common law, international law, European law, conventions, model contracts, we've heard about that. We hear about the WTO, the WCO, the WIPO, and then there's the transport documents and the non-tariff barriers on top of all of that. So these are some of the myths that are out there at the moment. You may well have heard of free trade agreements. Actually, they make things a little bit more complicated. More documents. There's a myth that the government will be giving the same amount of money as that we receive from the EU. We need to watch out for that. This is slightly tongue-in-cheek. The UK is not self-sufficient in oranges, and indeed very many things. So in our new world order, thinking that we're not going to remain, actually prices will change. And the last one, your business will not be affected by Brexit. It will affect everybody in some shape or form. So the implications of a no-deal scenario, we will, or companies that are trading in goods, will require to fulfill customs formalities. Goods from the UK to EU will have to do declarations. Tariffs for EU goods imported to the UK and UK goods exported to the EU. There is something that's just been issued about temporary tariff regime, which Mike will touch on later. And many goods will require documents to prove that compliance with EU standards. In essence, goods moved in and out of the country are subject to tariffs and customs checks. We've seen about Operation Brock. If your company is sending something overseas and the customs declaration is wrong, it will be held up, not just for your consignment, but also the 10 lorries behind you. Supply chains can be long and complicated, usually based on just-in-time principles. So we need to make sure that we are aware of all the steps in the journey to our products. So the current situation, customs procedures based on the EU code. the UK is working on its own tariff, and as it says here, the type of Brexit that occurs will determine whether UK will have the freedom to set its own customs tariffs within the World Trade Organization. Any transitory period will mean that we will stay with the EU customs rules until the end of that period. So what do you, as a British company, need to do now? Well, that depends on whether you are a producer and you sell your things overseas, or whether you're a service industry. And our presentation is very much on import and export. So I'm going to hand over to Mike for our 5 top tips.
Thanks, Linda. I'll do the clicker this time.
Oh, okay.
Okay, we've heard 5 tips from various presenters this morning, and we're going to look at some tips for both import and export. Now, you may already be successfully importing and export around the world. So for those people within the room that are doing that, bravo, and long may it continue. But you'll need to use that knowledge you have in-house moving forward with any no deal or deal with the EU. So please bear that in mind. Okay, first of all, you'll have received one of these glorious URI number registrations. Now, either you've already had one from many years ago, you applied and you were proactive for dealing with shipments between the UK and the EU, or you've suddenly received one of these letters in the mail from HM Revenue and Customs, and you've gone, what do I do with this? Unfortunately, there are quite a few traders within the Southwest that have come to me over the last 2 weeks and given me a phone call. Mike, I've received this letter. What do I do with my registration number? So in the workshop, we will tell you exactly what you have to do with this. Also, you may have received notification within the last 2 weeks on the TSP, or Temporary Shipment Procedure, that the government have just put in. And that, again, has been issued under a registration number. Now, these are all confusing documents that you may have to apply into your business going forward. So, importance of documentation. We heard earlier on certain legal requirements. This is another aspect of the legal implications of a deal or no deal scenario. First of all, what are the documents do I need to get my goods across the border? Well, number 1 is a full commercial invoice. But in the workshop, you'll see it's not just the labeling of the document commercial invoice that counts, but it is the information that is applied to those documents going forward. You'll need a full packing list to show customs at the border what goods are inside your box. Because the documentation that you supply will help any customs official, both here in the UK or in our European ports of entry, what is in your box. You'll need a certificate of origin. Increasingly, your European clients are requesting proof of origin for your product. If you cannot prove the origin, you will be in the mire, so to speak. You will not be able to move your goods effectively across borders. You will require a bill of lading or an airway bill, which is standard practice. If you're using a small courier, you'll have a stripped down version of an airway bill or a bill of lading. You will need a customs entry. This is fundamental. This is the only document that customs will approve of proof of export or import into your business. It is vital that you know how to do them. You know, if you're going to appoint a third party, like a freight forwarder or a customs intermediary, do you know the legal requirements that your business has to supply them to be able to do the customs entry on your behalf? And the proof of delivery. If you're an exporter, you'll need that document to say that, yes, the goods have been delivered on time to the destination as stipulated. You may also be needed licensing authorities. You may be dealing in goods that require an export license or an import license. You may be in the defense industry. You may be in agriculture. Who knows what business you have? Because I certainly don't from here, but in the workshop, we can go through the implications for your particular business. Insurance documents, import licenses, the same sort of thing. We're looking at technical and category and literature, etc., that you will require for your products in an overseas territory. Okay, and last but not least, the important origin certificate. All these are available and can be talked at the workshop. Now, you heard earlier that Linda briefly mentioned the dizzy subject of tariff code. Now, a lot of you have probably already gone through the painful exercise of classifying your goods with the UK or the EU tariff. But unfortunately, in a no-deal scenario, the UK will divest themselves from the EU tariff code, not the UK tariff code. And all will be revealed again in the workshop after these presentations. But in a nutshell, you must know what your product is used for. Hopefully that as exporters or importers, you know what it's for, what the material is made from, which is the more technical side of things, and is the finished product, is it a mixture of materials or is it a component of the original? All will be revealed. I'm not very good with paperwork. Next off, the determination of origin. Special rules setting out of the product quality and origin of the country. Now, country of origin is a mooted point. How do I prove that an item is of UK origin? This is up to the manufacturer or the supplier of the product to do this on the documentation before it even leaves your factory. It's no good putting it in a box, sending it up the road, and the goods being held by customs in Operation Brock, waiting for you to decide which origin. Because the Chamber of Commerce have the enviable duty of ratifying your certificate of origins on behalf of HMRC. And if you make a false declaration, unfortunately, the international law under the World Customs Organization will come back to haunt you. So work on the origin is a vital ingredient. And for the last point, prepare the customs declaration. Now, I have had many, many conversations with clients who have outsourced this task over the last 40 odd years to freight forwarders. They have stripped out much of the admin from their business and put it to a third party. Now, a customs agent or a freight forwarder, brilliant in their own neck of the woods, but how do you manage that? What instructions have you given to your freight forwarder or agent to be able to complete these customs documentations before you? We also have the thorny issue of a transit period. If we sign a deal agreement or we go to Brexit and there is a transit period, how long is that transit period going to last? Well, still on the statute books is the date of the 31st of the 12th, 2020. Now, that hasn't changed. So the preparation work you should have been doing for the last 3 years has now truncated itself into a 3-month period. So please be prepared. Linda.
Okay, so what do you need to do now? As Mike said, he's going to go into depth, and I would like to say that he is good with paperwork. It's just not this sort of paperwork. Okay, so we've got some immediate actions. If you haven't already done so, you need to register for your EORI number and decide whether you will handle customs declarations in-house or through a third party. Chambers of Commerce are excellent arbiters of advice, as are we, and of course the Institute of Export. Make sure that you've got the required documents for your goods, whatever they may be according to your your sector and your particular product or service. Check for updates on tariffs. There is the uk.gov.uk site does regular updates. I would suggest that you start following them for your product, and you make sure that your drivers or your freight forwarders are aware of the documents they may need at the border. And freight forwarders are generally very, very good at helping you. But as an exporter, you are always, always the responsible body to HMRC, not your freight forwarder. So the current situation. Oh, I've missed one. Okay, recommended actions. Discuss your preparations with your customers and suppliers. If you have customers in Europe, just think that if you're exporting to them or buying from them, they will need to know how to export or import as well. So keep close to those European customers. We need to retain our customer base, so that's really, really important. Incoterms 2020 have just been announced, so there will be some changes there. Plan for travel. Tell your employees that there's a workshop on that, and talk to your Chamber of Commerce. So importantly, recognise that the UK is given in high regard. Keep close to those customers, understand the concerns, and watch out for changes to EU regulations. Thank you. Thank you.
Okay, thank you very much to Linda and Mike. Their workshop will be highly valuable for those businesses that are involved with import and export. And lastly, I'd like to introduce Lisa Mulholland, who is going to give us an overview of the impact to immigration. Thank you, Lisa.
Hi everyone, my name is Lisa Mulholland and I'm an Associate Solicitor at Stephen Scone in Exeter and head up our firm's immigration team. I appreciate that there's an ever-changing immigration landscape for EU nationals in the UK, and obviously there's a huge amount of concern amongst local businesses about this in the lead up to Brexit. So my short talk will look at the current rules and obligations incumbent on EU nationals and their employers, and what needs to be done in order for such individuals to secure their status in the UK in the event of a deal or a no deal. So firstly, recent statistics have suggested that there's approximately 3 million EU nationals in the UK at the moment. And obviously those are the statistics that the Home Office and the government are aware of. So the numbers are likely to be far higher than that. And in addition to that, you also have their family members who may not be from the EU and also need to be taken into account. Well, firstly, you may or may not already know this, but there's no changes to the rights of EU nationals in the UK at present. And this is because free movement provisions continue to apply in the meantime. This means that EU nationals can continue to live and work in the UK, as was the case before. And employers can continue to employ EU nationals without the need to apply for visas or permission from the Home Office in order to do so. But we all now know that post-Brexit, free movement provisions will cease, which is obviously a huge change. But when this will happen is largely dependent on when or if we leave the EU and in what time frame. In the event of a no deal, free movement as it currently stands under EU law will effectively end on the 31st of January 2020, now that we have an extension to the deadline. However, much of the free movement provisions will remain in place under the EU Withdrawal Act until Parliament passes other legislation to repeal it. In the event of a deal, free movement from the EU will continue until the end of the transition period, which at the moment is currently set to be the 31st of December 2020. So many of you may already have heard about the EU settlement scheme. There's been lots of posters, government adverts, so lots of talk about the EU settlement scheme. But what is it and what does it mean for your employees? Well, EU nationals who wish to remain living in the UK post-Brexit will need to make an application to the new EU settlement scheme for permission to do so. And this will provide them essentially with the same rights to live and work in the UK as they currently enjoy. The scheme is now fully open after a phased introduction as of March this year. The application process itself, I don't know whether anyone has had any experiences in dealing with the Home Office, but this application is extremely straightforward. And it's important that you make your employees aware of that, because lots of people are nervous about submitting applications and what that involves. Essentially, there are only 3 basic requirements. The first requirement being identity. So obviously EU nationals will need to show that they're an EU national by providing their passport or national identity card. Residence. So evidence in their residence in the UK, and there is a criminality threshold as well. So it's only really a small minority of applications that will be refused under the EU settlement scheme, and that is usually for prolific criminal offenders. So EU citizens who have been continuously living in the UK for 5 years will be able to apply to stay indefinitely in the UK by obtaining settled status. But note, having settled status isn't the same as becoming a British citizen. EU citizens who are in the UK by 31st of January 2020 in the event of a no deal, or the 31st of December 2020 in the event of a deal, but who have not yet spent 5 years in the UK, will be able to make an application to stay in the UK, and this is known as pre-settled status. And these individuals, so don't panic, they can make an application to remain in the UK indefinitely once they've been here for 5 years. And again, that does involve making another application to the EU settlement scheme, but this time for settled status. Non-EU national family members who are living in the UK with their EU national spouse or parent, for instance, or arrive within a reasonable period of time thereafter, will also be able to make applications to the EU settlement scheme. So lots of people are panicking, yes, okay, well, our status will be secure, but what about my family member who isn't from the EU? But the government have announced that they will also honour their status in the UK as well. So I guess a point to note is that it's unprecedented, but all EU citizens wishing to remain in the UK after the 31st of December 2020 must apply in order to do so. And this is a mandatory process. I'm still hearing people, EU nationals, saying, this doesn't apply to me, I've been here for many years. It does. It applies to all EU nationals that are in the UK. And obviously this has also a huge effect on businesses as well, because you'll need to check that your EU national members of staff have the right to work in the UK. And it will no longer, not in the immediate future, but in due course, it will no longer be sufficient that an employee provides their EU national passport or national identity card as evidence of their right to work. So the deadline for applying to the scheme is dependent on whether or not there is if there's a deal or a no deal. So the deadline is the 31st of June 2020, 30th of June even 2020, in the event of a deal, or the 31st of December 2020 in the event of a no deal. And the current processing times for straightforward applications are approximately 5 to 6 working days, which is, again, very quick in terms of Home Office applications. And straightforward applications are usually for those EU nationals who've been living and working in the UK, so they're able to, they've got tax and national insurance numbers that can be linked to the HMRC. In more complex cases, where further evidence of residence is required, then the timeframes are approximately 3 to 4 weeks. But again, it's dependent on circumstances. So what happens in respect of EU nationals coming to the UK in the event of a no deal? Well, after Brexit, in the event of a no deal, EU citizens who move to the UK for the first time will be able to apply for a 36-month temporary immigration status called European Temporary Leave to Remain, or Euro TLR. Again, this scheme will be simple and made after arrival to the UK. However, as we appear to be moving towards a deal being agreed and ratified by Parliament, it may be the case that European Temporary Leave to Remain is never introduced. And this is because the government does plan to introduce a new Australian-style points-based immigration system in the UK from January 2021. And unfortunately, this new system is unlikely to provide favourable treatment for EU citizens, but instead favour highly skilled workers from anywhere in the world. And obviously what constitutes a highly skilled worker is up for discussion at the moment. So in terms of businesses, in order to sponsor employees under this system, businesses will be required to hold sponsor licenses and pay their migrant employees a minimum salary. And there have been discussion at the moment as to whether there should be a regional emphasis on the minimum salary requirement. So at the end of the transition period, free movement of EU nationals will end, and these individuals will become subject to immigration control in the same way as non-EU nationals are now. But employers, from your point of view, you will not be required to distinguish between EU citizens who moved to the UK before or after Brexit until the new immigration system is introduced. At this time, you'll need to be checking that your EU national employees do have the required permission to work in the UK. And these checks are commonly referred to as right-to-work checks. So I'd imagine as business owners, you'll all be aware of what right-to-work checks entails, and that it's important that you're carrying out compliant right-to-work checks, because if it transpires that one or more of your employees have not already obtained the relevant immigration status, and you've not carried out the correct checks, then this can result in fines of up to £20,000 per illegal worker. So it's huge numbers. So in light of this, I guess here are my takeaway points. Firstly, it's important that you reassure your EU national employees that nothing will change in the short term, but signpost them to information on the EU settlement scheme and remind them of their need to apply to the scheme before the deadline, as failure to do so can have serious consequences for them as individuals, but also potentially for you as businesses. Failure to do so, to make an application to the scheme within the deadline, can result in EU nationals becoming overstayers in the UK, losing their right to work. They may have difficulties renting property, opening up bank accounts, and even applying for driving licenses and accessing healthcare. So there's huge issues, and obviously how that's going to be rolled out, we don't know yet. So we don't know how stringent the Home Office will be on that, but certainly the indication is that all EU nationals who haven't applied for citizenship must make applications to the EU settlement scheme. Secondly, ensure that you're carrying out right-to-work checks on all members of staff, regardless of their nationality, and that you have effective systems in place to ensure that follow-up right-to-work checks are carried out in a timely fashion. And lastly, if you are noticing that there are gaps in your workforce and you're struggling to recruit for certain positions, you may want to consider whether or not it would be beneficial for you to apply for a sponsor licence. And if you already hold one, then whether it meets the needs of your business. Thank you all for listening. We don't actually have a workshop today, but we are out on the stand should anyone have any questions or anything they would like to talk about in respect of immigration. Thank you.
Thank you very much, Lisa. And thank you to all of our speakers today. We're going to take a short break where we'll have tea and coffee out in the next room. There are a number of exhibitors, including Lisa. Please go and talk to some of those exhibitors. Please see the chamber stand. Lisa, Jen and Ali will be on hand to give you some more information about joining the chamber. But I hope you've had a good morning, plenty to think about. If you haven't actually signed up for a workshop, hopefully the speakers have made your mind up for you. On your agenda, you have the rooms where the workshops are taking place. Thank you very much.